What's up, guys? This is Manoj Puptani. I welcome you all on behalf of the Edupedia world. Are you guys all set? Fasten up your seatbelts. We are about to take off with the fourth presentation on the Insurance Act 1938 with the first topic, and this will be about prohibition on rebates. This thing has been covered under section 41 of the Insurance Act 1938. So it talks about some of the rebates and their prohibition. So guys, this provision basically asks you up about a few aspects that you have seen many of the times wherein you get a call from many of the insurance agents over your call phone, and they ask you that, sir, ma'am, we are providing this offer, and this is on this particular offers or documentation with respect to this policy. So are you willing to take it up? They usually provide you some kind of incentives, rebates in that, but you'll get to know about this thing, that this is something which is prohibited. Okay, they just cannot offer you something which is just not available on the published document, that is the prospectus on offer document of any of the insurance policy agreement. So if in case the company has brought forward some of the policy and initiatives and rebates, yes, they can go ahead with the same, but they cannot basically seduce you or induce you with any of the kind of segment wherein they can ask you for providing them some undue benefit. Okay, so those kind of rebates, those kind of incentives, those kind of any premium that you will be getting over your policy or stuff, so this is something which has been prohibited by the act completely, and this prohibition on rebates is going to be considered under section 41 of the Insurance Act 1938. Now it again has three major segments. Okay, number one, prohibition on offering and accepting rebates. Number one, this thing has been covered under section 41 subsection 1. Along with that, it also has a proviso attached to it, which is no prohibition with respect to the insurance policy on own life of agent. Let's suppose agent is again himself taking up some of the policy and offering some of the discount to himself. So in that particular case, there will be no prohibition. This is a proviso attached to it. And section 41 subsection 2 talks about the kind of consequences that will happen in case if any of the agent or company come across any of the instances wherein they do any of the default. So what's going to be the consequences in that particular stuff? You'll be able to note all these things here. I hope you guys are pretty much clear with each and every kind of topic that I briefly make you understand on prohibition of rebates under section 41. Shall we proceed further? Perfect, guys, let's move towards the next topic, and this will be relating to the policy not to be called in question on ground of misstatement after 2 years. This thing has been mentioned under section 45, and a question has already been asked in a previous C final attempt for November 2012. Now let's suppose there comes you come across a situation wherein there was a misstatement in your offer document, okay, while you were signing an insurance policy. Now it's been almost 2 years have elapsed, okay, and you are just not having any kind of idea about that misstatement. Neither you are having that idea nor that insurance company is having that idea. Okay, and some misstatement went on like this, and you were and you are paying the premium accordingly, the same kind of statement. So now suddenly that misstatement came into the picture. Okay, and you got to know that till this time you were paying a premium which is excess or premium which is less than that, or some other mishap has occurred to the policy. Now do you think that will it be feasible to bring into that policy again into the question on the grounds of misstatement after a period of 2 years? Is it going to make that particular policy void merely on the fact that there is some misstatement which is involved in it? Dude, you have been already paying so many premium, so much of amount as a premium, okay, and you were just not having an idea about that misstatement which has happened in your policy. Neither the company, neither you are having that idea, nor that insurance company is going to have that idea. So don't you think it will be very much of an undue hardship on you as a policy holder if in case your policy is called upon in a question now, and the terms and agreements are being changed and which are detrimental to your interest now? That will be an undue hardship for you, and the authority knows this fact. Okay, this is something, the kind of story which I briefly narrated to you. This is exactly the same thing which we are going to read in this particular provision, that is section 45. So now I'll provide you an example, a beautiful example, in order to make you understand about this. Let's suppose while you were taking up a policy, you were aware that your age was approximately around 50 years. Okay, so if we go about the facts, so it's said in an insurance business, particularly relating to life insurance, that the older you are, the more you need to pay the premium. Okay, the younger you are, the less amount of premium you need to pay. Why? Because the age is quite large, and you just not are suffering from any of the medical diseases, fairly material one. So they usually provide you an incentive in this way, in a way that you need to just pay the premium at a very lesser amount. But since the people around who are like getting older, who are 50, 55, these are the persons who have like almost reached to the peak of their lives. Okay, the normal expectancy in India is around like 65 years now, around 60, 65, 70 years. So the person who will be like 50-year old definitely needs to pay more premium as compared to the person who is just 25 years old. So you were aware of the fact that you are a 50-year-old guy. Okay, not just guy, you are a man. Okay, so you're a 50-year-old man, but you tried to camouflage the situation yourself, knowing that, and you like misrepresented the facts, and you made some of the certificates or some sort of thing wherein you actually prepared all the stuff, and you kind of like convinced the insurer that you are just 25-year-old guy. Okay, so now you are paying the premium at a very feasible kind of step. For a guy who is like 25 years old, you are paying less of the premium, though you are 50 years old, and you knew it, this fact that you are 50-year-old, and you are trying to camouflage the situation. Okay, you're just not presenting or representing the facts in the correct manner. So now, if in case the insurer knows that since it was material to disclose about your age, and you fraudulently made some of that fraud as a policyholder, and you knew it at the time of making that statement, that the statement is false, and you are suppressing some of the facts which are material to disclose, then in that case the insurer can call upon any of your policy at any point of time on the ground of misstatement or misrepresentation, even after a period of 2 years. And this is something which is very genuine, which needs to be done. So law has been like the framing of the law usually takes up immense amount of time, and so many professionals are involved in it, and they know it, each and every bit of things which can happen. Okay, so misstatement not going to make the policy void, but having said that, that can happen if in case you knew that the statement made by you as a policyholder is false, and you try to suppress the facts, then the policy can be called in the question on grounds of misstatement after a period of 2 years. This particular statement has been like covered under section 45, and this question was asked in CE final examination for November 2012. But having said that, there is a right of insurer to call for proof of your age. Okay, so the person who is going to provide you the insurance policy, nothing in this particular section shall prevent the insurer from calling about your proof of age at any time. Let's suppose after a period of 2 years or 3 years down the line, they got to know that you are not a 25-year-old guy, you are a 50-year-old man. They can ask you to call upon and provide your proof of age at any point of time if you are entitled to do so. And no policy shall be deemed to be called in question merely because the terms of the policy are adjusted on subsequent proof, and that the age of the life insured person was incorrectly stated in the proposal. So on that behalf, your policy can be changed. Okay, it will not be called to be merely in question because of this particular age or proof measure. So in that particular stuff, this was all about the policy not to be called in question on ground of misstatement after a period of 2 years. I hope you guys are clear. Utmost kind of clarity with respect to each and every provision that I briefly narrated to you. Let's move towards the last provision of this particular presentation. So it talks about the power of central government to acquire undertakings of insurer in certain cases. This thing has been mentioned under section 52 subsection H, or I should say section 52H basically, because that's not a subsection over here. So power of central government to acquire undertakings of insurer in certain cases. They can acquire the undertakings of insurer. What all are those certain cases? Let's understand them one by one. Number one, order of central government for acquisition of an undertaking. So how a central government is going to acquire your undertaking? You are running up any of your insurance business, and central government just wake up one morning and thinks, okay, let's buy that, or let's acquire that undertaking which is being run by Mr. Ram or Mr. Ram. Is that going to be the case? Absolutely not. There has to be some grounds wherein you must have like made some of the default, or your conditions would be like detrimental to the public interest or the affairs of the trade. Then only it is usually the last resort which happens with to be a case with the power of central government, wherein they try to acquire your undertaking as an insurer. So you must have done something. So order of central government for acquisition of an undertaking, but when it's going to happen, this thing has been mentioned under section 52H subsection 1. So guys, if upon a report from authority, that is IRDA, central government is satisfied that the insurer is being managed in a manner which is detrimental to the public interest or to the interest of policyholders or shareholders, and that in the public interest and in the interest of policyholders and shareholders of such insurer, it is very much necessary to acquire the undertaking of the insurer, then central government may by notified order acquire the undertaking of such insurer with effect from such date as may be specified in that order. They have the power to acquire your undertaking if in case the authority do provide them the request. They'll provide them a report, okay, and once the same report is being received by the central government and they know that the kind of business that you as an insurer are doing, okay, it is detrimental to the public interest, it is prejudicial to the public interest and to the interest of your policyholders and shareholders, you are providing something which is just not possible in insurance in any case, okay, and you are providing some fake promises or something is being brought into the light where you are just skillfully camouflaging the entire insurance business of all the people around and you are hijacking that up. So they may like acquire, they may, if it is necessary for them to acquire the undertaking, then they may do so if in case they require that in public interest and in the interest of policyholders and shareholders. They can do so, so they can order for your acquisition of undertaking. I hope you guys are pretty much clear with the kind of this first subsection that I briefly narrated to you. Now, the next thing is extremely important and usually is a part of each and every kind of provision. Before taking up or before acquiring your undertaking, don't you think so that the central government should provide you an opportunity to represent yourself in front of them? Obviously, they need to do it. So they'll provide you an opportunity to show cause. Okay. No undertaking of the insurer shall be so acquired unless such insurer has been given a reasonable opportunity of showing cause against that proposed action. This thing has been mentioned in as a proviso to section 52H subsection 1. So now moving on to the third segment, that is the vesting of the assets and liabilities in central government. So after providing that reasonable opportunity, okay, and still you wish to the central government is satisfied that it needs to acquire the undertaking, okay, even after giving you an equal opportunity of representing your case in front of them. So now on that appointed day, okay, all the assets and liabilities of your undertaking as your acquired insurer shall stand transferred to in the account of central government, okay. That will be an appointed day wherein all your assets will be like all the assets and liabilities which were vesting with you will now get transferred in the account of central government. This thing has been mentioned under section 52H subsection 2. That appointed day will be mentioned in that specified order by which day it's going to get transferred. Now lastly, on continuation of the suits and other proceedings. So it simply says that if on that appointed day when the assets and liabilities are going to transfer in the account of central government, if on that particular day any kind of suit, any appeal or any kind of proceeding by whatever nature, by whatever name is pending by or against the acquired insurer, so in that case the same shall not abate or be discounted or be in any way prejudicially be affected solely by the reason of that transfer of the undertaking of the insurer, but that suit and appeal and other proceeding may be continued, prosecuted and enforced by or against central government. So what does this last provision actually says of this particular presentation? It simply says, guys, that whatever kind of suit, whatever kind of appeal, whatever kind of proceeding which was going on the insurer, okay, now that the same assets and liabilities have been like completely transferred in the name of central government. So now all those suits, appeals, and other proceedings, by whatever name or nature they are actually called, they will remain okay. They will remain continued and prosecuted. Okay, they shall remain continued and prosecuted on the name enforced by or against central government. Now, since you have transferred each and every kind of asset and liability on central government's name now, so all those suits, all those appeals, all those proceedings will also now be transferred at the name of central government. So it doesn't mean that if in case the central government is acquiring your undertaking, now all those suits or whatever appeals were going on will now be like abated. No, they shall not be abated, or they shall not be discontinued in any way. Okay, they shall remain to be continued and prosecuted, but now in the name of central government. Why? Because central government has acquired all the assets and liabilities of that insurer in the vesting of the assets and liabilities of the central government itself. So this particular section talks about completely relating to the power of central government to acquire undertakings of insurers in certain cases. I'll be taking care of you in my next presentation. See you over there. I'll be concluding this presentation of mine with a dose of motivation, and that will be: there is no achievement without goals. This is something which was mentioned by Robert J. McKinney. With this, thank you on behalf of the Edupedia world. Keep interacting via questions, queries, and YouTube comment boxes. I will love to answer each one of your query and grievances. Stay connected. That will help us in understanding your needs way, way, way better. Perfect, guys. I'll see you in the next presentation. Till then, take care of yourself. Stay blessed. Keep yourself healthy. Love you all. God bless you. Bye.